Want to start off by saying thank you so much, Happy State Bank, Joby Mills, who is known by everybody, for asking me to speak at a CLE for some of their estate planning and probate attorneys in Amarillo last week. I'd always told him I've been through Amarillo, but never to Amarillo, so it was a treat for me, and I really loved Amarillo. So my talk was on bridging the gap and how to navigate the abyss between death and probate. You know, as an estate planning attorney and probate attorney, I've been doing this for almost 30 years. And I'm finding more and more that there is just this huge abyss and black hole from the time someone passes until the probate administration actually begins. And I am working with more and more clients that just need to understand that it is overwhelming, but it's okay. And as a probate attorney, my job is to make that gap as small as possible and just to help them through the process. Way back when, when I first was a baby attorney and I was handling probate, a lot of times we would get the calls from clients that had lost a loved one maybe, a month ago, 2 months ago, a year ago. But we're just finding more and more that I am getting calls on someone that is about to lose a loved one, or the loved one has just passed away and they truly don't even know what to do, what to think, where to begin. So I tell people the first thing that you can do to try to narrow and close this black hole or abyss or no man's land as much as possible is in the pre-planning phase, and that's the estate planning. The staggering statistic is over 70% of Americans do not have a will. And I mean, that continues to blow my mind. I will just tell on myself, I did not have a will before we had kids. I had been married for many, many years. And I told my husband that I was going to go skydiving. It had always been a bucket list of mine, on my bucket list, something I wanted to check off. And I had an opportunity to go. And he only asked 2 things of me, knowing that I was going skydiving. Number 1 was to make sure I had my will in place. And number 2 was not tell him when I was going, but just to let him know when I returned. I got my will done the night before I got on a plane to fly to Austin to drive to San Marcos to go skydiving. So I fulfilled his first request. I told him, unfortunately, I couldn't fulfill his second request because I needed a ride to the airport Saturday morning. But telling on myself again, I was part of that 70% statistic until I absolutely knew that I needed to do something because, accidents do happen. But with the estate planning side of things, you've heard me do, videos before for the Ashmore Law Firm. Not everybody needs a trust, and I am a firm believer of that. I had an elderly woman that I spoke at her living facility. It was an independent living facility, and she was so sweet. She came up to me. I remember this as if it was just yesterday, and it was probably about 20 years ago. But she came up to me and she said, "Lori, thank you so much for all of the information you've given me, and I wish I would have met you 2 weeks ago because I just had all of my estate planning documents done. But do you mind coming out and taking a look at them just to make sure that it's all correct and it's what I need?" So I scheduled a time to come out to her again, and that next week she brought, her beautiful binder that all of the documents were in. And as I'm going through it, she had a revocable living trust, she had her will, and she had all of her powers of attorney and what we call disability planning documents. And so as I'm talking to her, I'm like, "Okay, Miss Smith," we'll call her Miss Smith, "do you have any real estate?" And she's like, "Oh, honey, I don't have any real estate. I sold all of my real estate years ago and moved into this independent living facility, and I just pay by the month." I'm like, "Okay, so what about, accounts, bank accounts, savings accounts, stocks, bonds, investment accounts? What does that look like for you?" And she goes, "Honey, I don't have any of that. I have lived a great life. I've used my money. I have spent my money. I get my Social Security check every month, and that's what pays for this facility and pays for everything that I need throughout the month." I didn't have the heart to tell her she didn't need that trust, and she paid quite a bit of money for the creation of the trust. And I knew I couldn't tell her that, and all I could tell her was the documents she had looked good. But all she really needed was a simple will plus all of her disability planning documents. So not everybody needs a will. Again, I'm sorry, I think I said not everybody needs a will. Not everybody needs a trust. Everybody needs a will. So I tell people to close the abyss and this black hole between death and probate. You know, you need to do your proactive estate plan, and that is to talk to a qualified estate planning attorney. And it's to give them a listing of all of your assets and what your specific goals and objectives are. I am now of the mindset, and have been for many, many years, that one size does not fit all. I have come across attorneys in the past, and not to say that they're good attorneys, but I've come across attorneys in the past and not so past where they'll take a trust and they'll just, replace names. For me, every single trust is tailor-made, or every single estate plan is tailor-made for what the client actually needs based on their specific assets and their goals and objectives. So to narrow this abyss, we do this pre-planning, and we do what's called non-probate assets. I can take a list of 2 assets to 2,000 assets to 20,000 assets, and I can take a list of every single one of those assets, and I can put them in what we call a non-probate bucket. And that means it avoids probate. As soon as a loved one passes away, it goes to exactly who they wanted it to go to, and it happens pretty smoothly and quickly. You have a transfer on death deed. That is where you draft a deed that says, hey, if I still own this real estate when I die, I want to give it to X or X and Y. And you file that in deed records. It works beautifully in a lot of situations. It doesn't necessarily work in every situation. And you also have to be careful if there is a mortgage tied to that real property, because even though the real property may go to who you wanted it to go to and the beneficiary you designated, the mortgage company is a different story. So again, it just goes to show you need to talk to an estate planning attorney that truly understands all of that. You also have your right of survivorship, pay on death, and transfer on death accounts. And that's where you just go to the bank and make sure that those designations are current with the bank, so that as soon as you pass away, you know that that account is automatically going to who you want. Motor vehicles. Texas Motor Vehicles has a website that has a bunch of forms on it, and one of those forms is actually a beneficiary designation form where you can designate where you want your car to go should you pass away. And then any beneficiary designations you can make on life insurance policies, on retirement accounts. However, my huge warning is do not ever, ever, ever designate a minor child as a beneficiary on anything without having the proper trusts in place. And so this also happens with the revocable living trust, is also a tool that we can use, that we can put our assets in, and it avoids probate, and it's just a smooth transition when someone passes away, and any smooth transition closes and narrows that abyss between death and probate. I will tell you, and I'm just going to get a little bit into the tax side of things. Right now, we have a $13.61 million estate tax exemption amount. It's a very large amount, and there are not a lot of people will fall into that category of dying with more than that amount where they have to worry about estate tax. And the top rate to pay for the estate tax above that amount is up to 40%. So we know that January 1 of 2026, as the law sits right now, it goes down to $5 million per person, and that's indexed for inflation. So we know the estate tax exemption amount will be anywhere between, say, $6.2 and $7 million. However, and I don't ever get political, and it's regardless of any political affiliation, but we do know for Vice President Harris, she has already come out to say her platform and campaign is wanting to lower the estate tax exemption amount to $3.5 million per person and have a graduated estate tax of 55, 60, and 65%. So while right now we may not have a lot of people that fall into that 13.61 million above that amount to have any issues with estate tax, If it does get limited to 3.5 million, it's going to put a lot of people into that category of needing some estate tax planning. So again, just something to keep in mind. So again, we talk about the proactive estate plan that I have my clients go through to try and make sure we narrow this abyss between death and probate as much as we can. The other is a will package. This doesn't avoid probate, but again, like I said, you don't want to be part of that 70% statistic like I was many years ago. And anything that falls into your will, your probate assets, you do have to go through the probate process on. But it is so important to make sure you have a proper last will and testament. You need to make sure if you have that last will and testament, you do have a little paragraph in there that says the independent executor has the power of sale. Title companies, when you pass away, they need to know that the executor has been given that specific authority. Otherwise, it can create issues, not to say they're unsurmountable issues, but it can create issues when you pass for your executor to sell any real estate without that provision in there. And then, of course, we have our financial power of attorney, which is called a statutory durable power of attorney. And as attorneys, we can choose to trigger what we call hot powers in those, where your agent has the ability to change beneficiary designations, to create revocable living trusts, to put assets in a trust, to take assets out of the trust. We use those hot powers in very, very limited circumstances, but it is something that is available to us, and frankly, with some clients, that is absolutely what they need. You have your medical power of attorney, if you're incapacitated, who makes your medical decisions, who can get to your medical records, whether or not you want to be hooked up to life support, who you would want your guardians to be should you ever need them, and disposition of remains. I know that sounds like such a horrible document, but it is what it is, and we find if you don't have all of these documents in place, especially that disposition of remains, you are widening the abyss and widening the gap between death and probate. A little story that we have, and we see it more times than we ever want to, but we did have a blended family, second marriage. The husband died. He had adult children from a previous marriage. And for probably about 8 or 9 months, the current wife and the kids were fighting over where to bury dad and what to do with his remains. And the unfortunate thing is dad could not be laid to rest until the courts, ruled on who had the say-so over his remains and the burial. And if he would have had the disposition of remains, he would have been able to appoint an agent to make all of those decisions for him. And better yet, he would have been able to give specific instructions as to how he wanted to be buried, where he wanted to be buried, and everything that he wanted to happen with that. We also do more and more of these declaration of mental health treatment forms. And, unfortunately, the fact of the matter is we have a lot of mental illness. And a lot of it is coming out more and more. Just with social media and with issues that kids and adults and the elderly have. And so there is this declaration that an individual that has been diagnosed with a mental illness can sign saying what they want to happen should they be having an episode and not able to exercise good judgment. And again, you may be thinking, why do we even need these? This has nothing to do with death. But again, it's those little things and decisions that are made on the front end that I can tell you can narrow that abyss. Also, business entities. We're dealing right now with clients that the husband and wife died very close together, and they had an LLC. It was a single member LLC, and we have a huge gap right now because we haven't been able to get to the probate administration side of things, and they had a very thriving company. And we don't have anyone that can step in because they didn't have all of the proper documentation for that LLC and operating agreement to make sure that they had someone that can step in and make that transition between death and probate a lot easier. So now that we've discussed the proactive estate planning, and I know that was a lot, now I'm going to go to talking about what happens when someone has just lost a loved one. Uh, Back, a few years ago, I used to tell my clients the first thing you need to do is breathe. It's a very difficult time that you're going through. So you just need to breathe first and foremost. But then I would tell them, just start as you're going through the house, collect, looking at accounts, looking at mail. Just starting a spreadsheet of accounts that that your loved one had, any statements that come in, creditors there may be, and just start a list of all of that. Start a spreadsheet, and then let's revisit things in about 30, 60, 90 days. That was always my advice. However, not recently, a year ago, I unexpectedly lost my husband, and I tell people that not to get the, oh, I'm so sorry, and I appreciate the condolences, but it definitely gave me, I don't say a different perspective, but I will say an additional perspective on what I do for a living with estate planning and probate. I know probate like the back of my hand. I've been doing it for almost 30 years. I have counseled thousands upon thousands upon thousands of clients about probate. But when you are thrust into losing someone, I imagine even if it was something that was expected, but specifically something that was completely unexpected and out of the blue, my brain just shut down. I couldn't, I could barely get through the day. I didn't even know where to start. I saw this massive mountain in front of me, and I thought there is no way I'm ever going to be able to get anywhere near the top of that mountain, much less on the other side. And so I did listen to my own advice to at least start breathing, but it made me understand how overwhelming it is to go through the loss of a loved one. And where do you even begin? I was so overwhelmed that I remember sitting in my husband's office and for hours looking around thinking, I don't even know where to start. So what that taught me is to make sure that you know who you want to help you. If you have a blended family or if you have a large family, I now tell people, be careful who all you have going through drawers, cabinets, and boxes to help you inventory things or clean things up or organize things. A lot of that is just something that you would want to do on your own, or a very trusted friend to help you go through those, because I'm here to tell you, after a year, I went through drawers the first couple of weeks after my husband's passing, and I felt, I had items that I knew I would need for the house, at any point in time. And I know I put these items somewhere, and to this day, I still cannot find them. And I know one of these days I'm going to be able to find what I need. By then it'll be too late, because chances are I will have already bought it. But again, you're in such a brain fog, and it's understandable that you want someone there. You keep just very specific notes on everything you're seeing, everything you're looking at, and take pictures. Inventory it all. Some of these things I did, some of these things I didn't do, and now a year later I'm scratching my head thinking, okay, I know we had that, and now I don't know where it went. Did someone come in? Was it taken? Was it not taken? Did I put it somewhere safe? Did I store it somewhere safe? So those are just tidbits of information and advice now that I can give my clients. So just, be careful who you have come out to help take care of organizing, cleaning up, throwing out, filing cabinets, drawers, rooms, closets, and things like that. The obituary. Yes, you want to give an obituary to let everybody know when all of the services are, and the times of the services, and where, the location. But think about it. We are giving someone's legal name on this obituary to be seen by everybody. We're given a date of birth and a date of death. With the internet these days, you can find anything and everything out about everyone, and now you're giving someone a lot of information. So I tell people, make sure you have someone at the house 24/7, especially when the services are happening. Make sure you have someone staying at the house. We like to think that humanity is good, but the unfortunate thing is there are just some really bad people in this world that go through all of the obituaries and think that that's the perfect time to hit a house. So again, make sure that you have someone there at the house. Funeral arrangements. these funeral homes, these cemeteries are absolutely amazing. And I have worked with some of the best. But the bottom line is it is a business. And, we had a lady that lost her husband, and she went to the funeral home. And before she knew it, she had signed off, on a spectacular service and funeral, but it was to the tune of $80,000. And I tell people now, make sure that someone goes with you when you're talking to the funeral homes, when you're making these arrangements, and don't be afraid to pump on the brakes. If it doesn't feel right, just pump on the brakes. Tell them you need a second just to breathe and think about it, and that you'll get back to them. Don't ever be afraid to do that. Death certificate, order it as soon as possible, obviously. But I also tell people you better be careful, because a death certificate is a legal document. All of the information needs to be correct. And if you are an informant on the death certificate and you decide to give yourself a different relationship than you actually have, it's a legal document. You can get in a lot of trouble for that. And we've had boyfriends and girlfriends be the informant on these death certificates and list themselves out as spouses. Or we've had a caretaker list themselves out as a child or as a sibling. So you just need to make sure that the death certificate is absolutely correct. You need to make sure that if you have a boyfriend or girlfriend go with you to the funeral home, if you've lost a child, make sure that how anyone is signing, that they're using their complete and truthful relationship. So again, we get so caught up as an attorney, we get so caught up in the big picture of things and the complicated things that we truly lose sight of just the simple stuff. And I have more clients now that will come to me, and it's just the simple things and the simple advice that I'm able to give them now that I've lived through it myself that has helped them the most. I also tell people, be careful what you throw away. This was in a guardianship case. However, it could have very easily, and we see it happen in a lot of probate cases, but we had an elderly individual, a lady, and we were going through cleaning up her house, and we came across empty shoe boxes and the pantyhose drawer with the pantyhose rolled up. We came across the medicine, the cough syrup boxes that were empty, Band-Aid boxes that were empty. And of course, the first thing we're going to do is throw it away. We knew enough, because she was a product of the Depression, that those that lived through the Depression didn't trust banks, and so they would stash cash throughout their homes. We found over $200,000 of cash in her home by going through every single drawer and every single box and every single empty can to see where she had the cash. So again, just be careful as you're cleaning things out that you're going through everything, because you'd be surprised at what you might find. So again, although this abyss does exist, I always hope that the helpful hints and tools that I can give with the proactive estate planning, as well as the things that you really need to consider when someone does pass away, that will help make the abyss feel a little more manageable. I will also tell you, and again, based on all personal experience, sprinklers. When someone passes away, when you lose a husband or a wife that was in charge of a lot of things in the house, you need to make sure that you're on top of all of that. Sprinklers, I didn't even think about them. Are they on a timer? Do they still work? Are there any that are out? I think I went many, many months without my yard getting watered, and it just was not even on my radar. So again, little things that you need to think about. If you have someone that passes away in the heat of summer, have someone come out and check the AC unit. My husband took care of all of that. Never had to give it a thought. And now, I think after a few weeks after his passing, I don't think my house is getting as cool as it should be, and it's always on, and I had to have someone come out. So those are just little tidbits of information. Change the locks. If it's a blended family, if a lot of people have the keys, just change the locks. That way you have control of who you give your keys to. So again, little bits of information. Now we talk about the probate administration steps. Of course, you file a will. I tell people you always need to make sure that you have the original will. If you don't have the original will, a copy can still be probated, but we have a lot more hoops we have to jump through, and there's no guarantee that we can be successful in probating a copy of a will. So you always need to make sure that you do have that original will, and with as great as copying is these days with these colored printers, we have certain tests that we can do on a document to know if it's the original or just a copy. Of course, you appoint the independent executor or the administrator of the estate. Sometimes we choose to ask that it be independent of any court jurisdiction or court approval of any sort. And then there are times where we want the courts involved. We want the judge involved. We want the judge to tell the administrator what they can and cannot do and sign those orders. And again, we have specific reasons for wanting that. Inventory of assets. This is incredibly important. I always recommend to all of my clients that they get a CPA early on that understands estates and estate tax returns, because you have a step up in basis when someone dies. So if I had a piece of real estate that my husband and I paid, say, $200,000 for it, and when he passed away, it was worth $1.2 million. That's our new basis. So if I have to sell that real estate for $1.3 million, I'm not paying capital gains from the $200,000 to the $1.3 million. I'm only paying capital gains on the $1.2 million to the $1.3 million. And again, you have to make sure the legal documents that get filed in the probate administration side of things matches what the tax return shows. So if you're dealing with real estate, you need to make sure that you get it right. You need to make sure that you have the proper values in there, or else there can be unintended tax consequences. Depending on the client, you may want a formal appraisal now of real estate. And even if you have a business, if you have that LLC, there are times where we need to get a formal appraisal of that LLC. If you owned a piece of real estate, if your loved one had a piece of real estate and it was their homestead and they were getting their over 65 homestead exemption, if now a child inherits that real estate, you have got to make sure as the attorney, and if you are the beneficiary, make sure that your attorney files the proper deeds. We had an instance where we had a client contact us probably 4 years after they lost their loved one. And they were told, they came to us and they said, hey, probate was done a long time ago, but now we're getting these invoices and letters from the taxing authority, local taxing authority, saying we owe, over $150,000 for taxes. And I've been paying the taxes every single year. Well, the problem was at that time, there was not a deed. A deed wasn't done to transfer the homestead from the decedent over to now the child, and it was still having the over 65 exemption. And once the taxing authorities caught up with all of that, it wasn't just having to pay now the entire tax every year, but it was all of the penalties and interest that accrued on it. So it was a very large bill and not a lot that could have been done with that, other than making sure that all of the proper deeds are filed when someone passes away and you have the legal documents that you need. Another thing is the period for probate. A lot of people may not know that you have, attorneys know, but you have 4 years to probate a will. That's why I tell clients you've got time. But if you do not probate within that 4-year period, then it's as if your loved one died without a will. That has unintended consequences, because if the will gives something to, say, maybe 2 of the 3 kids, and they don't go through probate, if it's after 4 years, that 3rd kid now has a part of the estate, which is not what the parent wanted. And so a lot of times, even though you may not have to be going through probate at that specific time when you lose a loved one, we sometimes make the decision with our clients to probate the will just in case. If they think that there could be additional assets out there that they really don't know about, then we might want to go through probate. I also tell people, believe it or not, look at the state comptroller's office when you lose a loved one, because there are a lot of times where people have money at the state comptroller's office that they never know about. And that can be a reason to go through probate, because it's very difficult to get the money out of there when you do lose a loved one. Of course, heirship contests. If you don't have a will, and I'm in more and more cases right now where there was no will, and the individual passed away, not married, no kids, so it goes up to their parents and then their parents' descendants, so their siblings. And we have a case right now where the loved one, the deceased loved one, was very, very close to his maternal family. Never really knew his dad, other than his dad, they knew that his dad, when he was young, moved to another country. And there was a firm out there that saw that he had millions of dollars, and they hired an attorney and they hired a search firm to find family in this other country where dad moved to. And now there are heirs that he never knew, that the family never knew, but that get a portion of his estate. And so you never want to be in that situation. Why the proactive estate plan is so important, because when you are faced in that kind of a situation, it just makes that abyss so much wider, and just it's a black hole. So I also tell, and this is where I end, but creditors. I tell my clients when they just lost a loved one, don't pay any of the credit card bills. Obviously, the maintenance of the house, utilities, yes, you need to pay that. You need to make sure that the insurance is up to date. If the house is going to be vacant, you need to make sure that you have the adequate vacancy insurance. But don't pay the medical bills immediately. Don't pay the credit card bills immediately, because in the state of Texas, as we know, as attorneys know, as clients don't know, there's a priority and a timing of how all of the creditors and debts get paid. And if there's not going to be enough money, then not everybody gets paid. Or there are certain assets that are exempt, where it goes to the family. It goes to the spouse, and no creditor can touch certain assets. And so I tell people, just be very, very careful when you first lose a loved one. Don't just think that you have to get these credit card bills and just start paying immediately. Just take a breath, write them down, start the spreadsheet, and then talk to the attorney to make sure that you're paying those properly and timely when the time comes. So my hope is, with this presentation, for attorneys and for clients, is that it gives them a lot. It's a basic presentation, but again, going through the experiences I have gone through this past year, it has made me truly understand that it's just the little things that attorneys lose sight of, because we are looking at such the big picture a lot of times, that it's just those little. It's just the little stuff and the little advice that we can give our clients that just make so much difference. So I hope you enjoyed this presentation, and if you ever have any questions, just give us a call.